All right, thank you so much for having me here today, and welcome everybody here and to those on Zoom. I understand that I'm supposed to talk for about an hour and then we'll have half an hour of Q&A, but if there's any clarifying questions, if anything's not clear, please feel free to jump in. And I'm actually going to ask for your input as to which topics we address, because I have more than an hour's worth of material to talk about, and I'm happy to talk about any of my research in this area. So I'm going to ask you which topics you want me to talk about, and I'm happy to talk about any of them. So essentially, I am a Supreme Court behavior expert as my primary area, and I've done a lot of work on oral argument. And I really like studying oral argument, partly because it's the only public part of the Supreme Court decision-making process. So it's really the only part of the process that we can watch and analyze and also get data on. I like to do empirical analysis of this sort of thing because everybody has their opinion on the Supreme Court and particular justices, and it's really interesting to see how much of that we can actually bear out by showing it in a sort of rigorous, large N statistical study. Which is not to say I don't like doing doctrinal work and anecdotal work. I usually combine all of those things together. And also I'll use those different formats. So I'll use particular examples to illustrate some points to you. But I'm also going to show you some large empirical studies. And I'm going to present that mostly in graphical form, which I think makes it fairly accessible. But please feel free to ask what's going on in the graphs if it's not clear at any stage. Okay, so I have a bunch of different projects that I've done in this area, and I've reduced them down to some questions that that cover these areas essentially. And so these are the 6 main areas, and I'm happy to talk about any of them. And these are links, so we can jump around within my slide, assuming the links work, which they usually do. What I thought I would start with, what I usually start with, but I really am happy to talk about any of these topics, is gendered interruptions, because this is the thing that I'm most well known for, is essentially showing that the female Supreme Court justices get interrupted sometimes, some years as often as 3 times as often as the male justices. And so it's an interesting study to look at how do you analyze that as a launching pad. And then also, what does this tell us about oral argument? What does this tell us about the role of the Supreme Court? What does this tell us about gender equality in society generally, if this is even happening to, some of the most highest status women in society? So that's the first question. And the second question is, what role for the Chief Justice? So when I originally did the first study on gendered interruptions, one of the things I called for was for the Chief Justice to intervene more, to actually stop this unfairness, essentially. And he has done that more. And Justice Sotomayor was actually kind enough to comment a couple of times on my work and say that it really changed the court. And so what I did in a follow-up study was to basically look a gift horse in the mouth and say, well, did I really? And so as part of that first question, we can look not just at the original study, but I'll show you the updated version and see what's changed since 2017 when I first started studying this. And then the second question concerns, well, what has the Chief Justice done about it? And so how does he intervene to try to address the gender inequality that we see at the court? So that's the second question. The third question is, why are Supreme Court oral arguments so fraught? And that's sort of a little bit of a whimsical way of introducing a more general topic about how has Supreme Court oral argument changed, and what does that tell us about the Supreme Court and its role in the political system? And essentially what I show in that project that addresses that third question is that the Supreme Court justices are highly strategic, and that has changed over time. So the way in which the justices behave has changed over time. And I put this down to the political polarization that we see within society and the changes that we can map within Congress and the public in terms of the separation between the parties and the lack of middle ground that we see in the country generally, which we can measure, which political scientists have measured, not me. But then to take that and say, well, how does that map onto what's going on at the court? And it's some really interesting results in terms of how the Supreme Court, and essentially the title of that paper is the new oral argument, Supreme Court Justices as Advocates. So essentially the justices are behaving strategically and they are advocating for particular causes. And we show that in a variety of ways. The fourth question is a bit more lighthearted, and but actually ties into that same topic, and it's what does laughter mean at the court? There were some work, some pre-existing work, not a lot, that looked at laughter and characterized it as an equalizing force in an otherwise hierarchical institution. And I just didn't believe that. From listening to a lot of oral arguments, I was like, no, that's not what's going on here. And so what we do in this project is we have a bit of fun with the laughter at the court, but actually show it's part of that same strategy, that the justices make jokes strategically. And it's some really interesting, I don't want to give away everything that we find there, but that's what the fourth question addresses, and essentially shows just how performative the justices are and how they do it in a very strategic way. The fifth question has a little bit outdated. I don't think we'll spend time on that, but essentially it was a project that's saying, even during the pandemic, when the Supreme Court switched to a very structured system where the justices spoke in order of seniority, and there wasn't really a chance for interruptions, there was still a gendered effect in terms of interruptions, and it was primarily by the Chief Justice who controlled the structure of the argument. And then the final question is, what effect do institutional rules have on this aspect of decision making? And this is some comparative work that I've done looking at Australian High Court oral argument. And essentially, Australian High Court oral argument is measured in days, not minutes. And so you'd think, okay, well, it's not going to be fraught in the same way that, you know, the 60 and now 90-minute arguments at the Supreme Court are. But what we show is that almost all of the same strategic behaviors occur at the High Court that occur at the Supreme Court. And so it's interesting to think about why that is. And there's a bit of an idea out there in Australia, I can tell you that, I'm Australian, so that, oh, you know, the US Supreme Court, it's so political, not like us. We're lawyers, we care about the law and we don't behave like that. And we show that's not true. And that the same sort of strategic behavior happens. And also what's interesting is that some of the findings that we've showed in the American context is, for example, that conservatives interrupt more and liberals are interrupted more, which raises interesting questions about, well, gender and ideology and how they interact. And what's interesting is that in Australia, we show the same effect, even though there have been periods where there have been a liberal Chief Justice and a liberal majority on the court, and we still see the same patterns. So it's quite informative about, well, what's going on in America then, given that we've only had conservative domination of the court since 1969, which is sort of when Supreme Court oral argument changed anyway. So some interesting insights, not just about Australia, but about what other countries can tell us about the US. So that's that final topic, if we get time for that. But we don't have time for all of this, so we'll ask you to choose. So do people have particular topics they want to hear about first? Or yes, please. Number 3, number 1. Is that a number 1?
Chief Justice.
The Chief Justice? Yeah.
I think 1, because it sounds like so many of the other questions are related to the gender. I agree.
Okay. All right. Well, let's just start from the top. I think we will get to 3. I'll try not to go on too long about any particular point. So we should be able to get through 1, 2, and 3, even if that means we miss out on laughter, which is one of my favorite topics. Okay. May I interrupt? All right, so first of all, how do we do this? If you've listened to oral arguments at all, you can go on to this great website called OIE, which has all of the arguments since 1955. And as well as listening to them or reading them in transcript, you can do both at the same time. And you'll have this screen where the transcript comes up and it actually shows you who's talking at the same time. And so it goes down. And so what's highlighted is the person who's talking at that moment. And so what we see here is you can see a dash a couple of places in this line, right? Dashes that are in the middle of a speech episode are just indicating a stutter, somebody saying a word, reaching for a word, you know, something like that, right? I'm illustrating. Whereas a dash at the end of the line means that the person was interrupted. And so we can identify the interrupter, in this case was Elena Kagan, who's the next speaker. And so all we have to do is write an algorithm that essentially says, take any dash at the end of a line, and that's an interruption, and code who the speaker was and who the next speaker was is the interrupter. And we can code for things like how far into the speech episode was the person before they were interrupted. So were they interrupted 2 words in or 5 minutes in when that person just couldn't bear to listen to it any longer. And actually, if we have time, I'll talk about they're actually 2 very different types of interruptions that signify different things. Okay, so that's what we're looking at. Let me give you some examples. So this is the rule, the Supreme Court rule that says you can never interrupt a Supreme Court justice. This is instructions to the advocate. Stop speaking immediately if a Supreme Court justice interrupts you, because that's totally fine. It's fine for the justices to interrupt, but not the advocates. And yet, what do we hear?
In which the school basically agrees, okay? If you don't consider race, the holistic percentage, whatever it is going to be virtually all white.
And that is an assumption that has no basis in this record.
Oh, but
It's
there
a
is.
stereotypical
Assumption.
That's
It's
what it is.
not, because
That's
the
what we all
reality
reference.
that Justice Alito wants to rely on. Let me finish my point. He's right.
So that's Justice Sonia Sotomayor, the most interrupted justice of all time. We can talk about what it is that's specific about her other than gender. Perhaps race might be a factor. We see repeated interruptions by a male advocate. And then we also see, this is what we call an intervention by the Supreme Court, by the Chief Justice. He steps in. And in this case, Justice Sotomayor doesn't need him to step in because she says, let me finish. And you've upset, you've done badly if the Supreme Court Justice is saying that to you, but that's an example also of a Chief Justice intervention. Okay, so here we have multiple different interruptions by the advocate of the justice. Okay, as I mentioned, this is Justice Sotomayor very kindly saying some nice things about my first paper in 2018 and saying that some of the justices apologized to her. And then again in 2021.
Published a thoughtful empirical study titled Justice Interrupted: The Effect of Gender, Ideology, and Seniority as a Supreme Court Oral Argument. They found, based on examination of oral argument transcripts, that female justices were disproportionately interrupted by their male colleagues and by male advocates. Similar results obtained in a study of gendered interruptions on the Australian High Court. Have you noticed this dynamic of your time on the court? And how do you respond when you get interrupted?
Well, I respond in a way that perhaps I shouldn't, which is I interrupt back, which is not the idea. As a credit to those researchers, by the way, Kennedy, I know there's often conversation as to how much influence research has on the courts. In the case of that study, I think it had an enormous impact. I know that after reports of that finding came out, that our chief judge was much more sensitive to ensuring that people were, if not interrupted, at least that he was playing referee when interruptions happened and ensuring that people got back to the judge who was interrupted. I also found that my colleagues are much more sensitive than they were before. You will see us even now when we're speaking, a judge will say, I'm sorry, did I interrupt you? And if you say, I was going to finish something, we'll say, please go ahead. That did not happen as much before. And so that study kind of made it.
So that was very kind of Justice Sotomayor to comment on this a couple of times, but it does raise the question, did things really improve? Is it true? Please.
The context this question was asked and answered.
She was having one of these public forums where she was talking for an hour or so on various topics, and then the speaker asked her about, because she'd previously said, I think that this project had influenced the court. He followed up and asked her to detail more, and she went into that detail, which was very nice. Yeah. Yes.
Do you have any more recordings on your PowerPoint?
Not for a while. I can give you a sign, or I can skip them as well.
Well, no, it's just that
It changes the sound.
Well, the people on Zoom can't hear it very well.
Oh, okay.
We can hear it in here. And
Okay.
So it would just be resharing the screen with the sound on, but if there's not going to be many more, then we won't.
No, I think there's, I have some examples. No, I think they're only in laughter, which we're probably not going to get to. So, yeah. Okay, so the questions are, did interruptions really improve? And did the gender imbalance improve? So she claims that interruptions went down, but also that they became less gender specific. And then also, is it true that the Chief Justice became more of a referee, which is the other thing that she's saying. And so we decided to test both of these things in the follow-up study. Okay, first of all, let's just look at interruptions. So here we have on the y-axis the number of interruptions, and just this is term, right, along the x-axis. And so you can see a pretty clear increase over time going up, number of interruptions increasing. And in that third question that we will hopefully get to, we'll explain like more generally what else is going on at the court, the sort of the political dynamic at the court, but let's just focus on interruptions for now. Now, the other thing you see, as well as the pretty clear upward trend, is this 2020 term, which is when they were on the telephone and had that very structured form of argument. And so some of the analysis could lead you to think, oh, interruptions have actually gone down. Like if you, as you'll see, if you average just the time after the study, it's actually significantly lower. But if you ignore this year, the overwhelming trend is still upwards, but it's just artificially low. Yes, please.
You know, it's 3 liberal justices, right? And Coney Barrett, is she interrupted as much as the other 3?
I have a slide on that. We'll hold off on that because we'll get to the slide, but it's a great question. Yeah, and there was another question.
Yeah, the argument, that means the entire hour or 90 minutes, or is that per speech?
No, for the like the 60 or 90 minute argument. Yeah. Yeah. This is just justice to justice interruptions. We look at advocate to justice interruptions as well. But given that the number's supposed to be 0, yeah. Okay, so that's just pure number of interruptions. Here's now the gender divide. And so you've got the number of interruptions of the female justices. This is just by other justices in the gray squares, and then the male interruptions in the black circles. And so you can see since around the early 2000s, there's been this gender divide, and the gender divide looks to be getting bigger as well. Once again, with the exception where they're basically equal here, otherwise. So it looks like if you look at just the post-2017 period, you could think that it's going down, but actually, if we say that, you know, this year should really be ignored because different rules applied to it. And so we break that down into more detail. This is what it looks like. So it looks like things are improving because in terms of the post-pandemic period, like the numbers are going down, but we think that's a little artificial. Whereas if you break it down by year and don't look at 2020 when interruptions were low and not as gendered, so they were gendered in a different way. So in 2021, when they came back to the new system, when they were back in person, they were up 123%. And the difference between male interruptions versus female interruptions. So that's not a great sign of improvement. It does get a little bit more positive, but okay, Justice Barrett. So Justice Barrett, we were like, okay, so we know that ideology matters as well, because I've shown that in other studies. So Justice Barrett is interrupted by another justice about 0.65 times per oral argument, whereas the female justices are interrupted about 50% more than that, and the male justice 50% less than that. So gender and ideology essentially are playing off against each other. So that Justice Barrett is right in the middle between the female liberal justices and the male conservative justices. Yeah.
Hey, for me to interrupt you now with this question.
Sure, yeah.
What about female and female attorney, female justice, or female justice to female justice?
So in our original study, the female, so in all social science, there's been every study on interruptions long before my work showed that everybody interrupts women more than men, women and men included, right? So women interrupt women more than they interrupt men, and men certainly do the same as well. And it's same for studying little boys and little girls, etc. People learn gender dynamics very early. I don't have the numbers with me in terms of female to female justice interruptions, but in the original study looking at advocate interruptions, we looked at that specifically, and the female justices, female advocates were barely interrupting anybody. They were actually following the rules, whereas the men weren't and were allowed not to, right? And so it said something about, I think, the expectations put on female advocates in a very male-dominated atmosphere. Men are still about 80% of the Supreme Court bar appearances. that women are just expected not to behave that way. So I don't have the exact numbers for you, but overall, I think that effect holds. Yeah. Yes. Yes. Yeah. Yeah, I can show you a slide. I'll show you a slide that actually breaks that down in terms of a net interrupting. So who's interrupting more than they are interrupted? I'll get to that very shortly. Okay, so here we are now getting to the advocate interruptions. So now we see the advocate interruptions, same gender pattern starting in the early 2000s. The female justices were significantly more interrupted than the male justices. But it's here, it looks like maybe it's smaller here compared to some of these large gaps. So we'll look into that a little bit more. Yes.
Can we revert to the previous slide?
Yeah, which one?
Back to Justice Sotomayor. Was that one interruption or multiple interruptions? How did that?
It was multiple interruptions. So every time there are actually, we've coded it different ways. You can do it by speech episode, you can do it by interruption, and the results are all the same, whatever numerator or denominator you use. Sure. Okay, so here we looked at essentially, if we look at it just in terms of year, and this essentially shows us what we've already talked about but just showing these statistically significant effects that we see the female justices still being interrupted more compared to, like in the Rehnquist era, we didn't see that effect. And in the entire Roberts era, we do see this significant difference in terms of gendered interruptions. And then if you look at male versus female advocate behavior being different as well, you see that's actually varied. And it looks like it's not happening in this last era, but once again, we've got that averaging problem with the 2020 involved. So let's break that down a little further. If we break it down and look at 2019 versus 2021, what we see is that we don't see the male and female justices being interrupted more this is just by the advocates. So we still see the effect for the justices, but the advocates do not seem to be interrupting the female justices more than the male advocates. But it's only one term, but we don't see an effect. But we do still see male advocates interrupting more than female advocates, which I think was, it doesn't exactly get to the exact question, but it does get to that sort of gendered behavior. Yes?
You also take into account tenure, so younger justices interrupted younger.
Yes. Yes, so younger justices are interrupted more, but the size of the effect is tiny compared to gender. But we did look at that, yeah. All right. So, so that's essentially the most up-to-date information on the interruptions, the gendered interruptions. Sometimes I get a question about, well, why does this matter? Who cares? It's not that many interruptions, etc. And I talk about, well, you know, women, the female justices get to ask their questions. They get to also influence the discussion. Like the justices don't meet before oral argument. The first time they meet is at conference after oral argument, where they go through an order of seniority how they think they're going to vote. And so the most junior justice doesn't get to speak until everybody else has already said how they're likely to vote. And Justice Kagan told me that because of that, she talks more at oral argument and asks questions, not just trying to get to the answer with the advocate, but trying to influence her colleagues. And so if she's being interrupted while she's trying to do that, she's not only not getting her question answered by the advocate, but she's not getting to sort of get in the minds of her colleagues and try and coalition build as well. And so this graph, which is a bit hard to read, is essentially looking at everybody to the right. They're much more likely to vote separately if there's been an interruption. And people on the left, the four justices where that's not true. But generally, this is a part of a study that's showing that interruptions are a form of conflict. And actually, this is the better. The chances of you agreeing goes down from 60% to about 45% with 3 interruptions. So 1 interruption decreases the chance of voting together, 2 justices voting together where there's an interruption between them by about 13%. And then the next interruption adds more and the next interruption adds more. So it's a sign of conflict. Which way the direction goes is a fair question. We don't, we can't really answer that. Like, are they interrupting each other because they're likely to disagree, or are they disagreeing because there's this conflict between them? But either way, it shows that interruptions aren't just sort of these random things that are happening. They're associated with disagreement between the justices. All right. Don't need to talk about that. Okay, so another final point coming out of this interruptions part is to say, well, what do women do about it? What do women do about the fact that they're interrupted more? And people often ask me, well, what should the justices do? What I can tell you is what the female justices do. And overwhelmingly, the female justices have this graph of their, what I call prefatory polite language. So earlier I got a question, somebody said, may I ask a question? And that's the kind of language we talk about, right? Often men, actually I'll show you the contrast. Men come to the court, almost every man comes to the court using that kind of language. I'm sorry, excuse me, can I ask a question? May I ask, Mr. So-and-so, Ms. So-and-so, etc. These prefatory languages to say, I call it throat clearing. I'm about to ask a question, but I don't want to jump in and be rude. And the men just don't do that. They just ask their questions, right? Whereas the women all have this downward slope to that kind of language. They change the way they speak, I think, because they know they're getting it. So that they learn over time to stop being so polite and just jump in and ask their question and don't give the other person a chance to interrupt so much. The exceptions, I think, are illuminating as well. The men who do use polite language, Justice Rehnquist was typically impolite until he became Chief Justice, and then suddenly he became polite, right? And so that tells us something. The only other example of a man who really changed and became more polite was Justice Douglas, and that's as he's getting sicker and sicker, right? So he's trying to say, hey, I've got a question to ask in his, by then, quite weak voice. So it's interesting. So what happens? Women change. Women become more like men, is essentially the lesson there. All right, yes.
Because Sotomayor really stands out here.
Yeah. Sotomayor, at first we did this, if you break the graph down by year rather than term, at the very beginning, her slope goes like this. And then, so maybe she learns in the first few months. I think also there are different stories we can tell, and it's just purely a story that, maybe she's, because of her racial background as well, she's figured out coping mechanisms more. That's all just pure speculation, right? But yeah, Sotomayor is different. She came in the first 3 months of like October, November, December in the first term, 2009, she was on a slope like that and then down, but not that much data. So I don't want to rely on that too much. Yeah.
The language reflected in these graphs include something as simple as just saying like counsel and the same question.
Okay. Yeah. I think certainly the advocate's name. I'm not sure about just counsel, but that could have been. It's under-inclusive. Like I was just thinking, okay, what words do I hear a lot that are prefatory? But counsel was actually probably a good one that I could have included.
Do you see like linguistic patterns used more with women than men, or rhetorical tropes more with women than men?
Like, what do you mean, like linguistic patterns? Like, you mean specific
like
phrases?
Upspeak more.
Oh, right. Upspeak, I have not looked at that. That involves analyzing the sound, not just the transcript itself. Somebody has done some work looking at the sound of transcripts. I don't know if they've looked at upspeak. Or actually now in my next project is looking at the content more of oral argument. So this is a sort of skirmish into that area.
Really
yeah.
interesting.
The thing I've noticed is like Justice Alito says well when he's about to really go on the attack, and he pounds the table as well. So I'd love to have sound factored in. No, but I think now that we're getting technology that's better at analyzing the content of language, there's going to be more of that, and I'm certainly going to do more of it, but I haven't done it yet. Any other questions? So that brings us to the end of interruptions. Any questions on interruptions, or we'll go on to what the Chief Justice is doing about it. It's up the back.
As you speak, it seems like each justice would love to know exactly what you're seeing in order to strategize for their own actions like that and things like that. They probably noticed that,
yeah,
of course.
Yeah.
But at the same time, the way you've spoken about it, it would be like, yes, I'd like that guidebook.
Yeah.
Myself, especially as you enter into the court.
Well, actually, so the third question, number 3, which we will get to, is actually showing how you can predict how the justices are going to vote as well. And so I have done a little bit of consulting for firms, like looking at that, not as much as I'd like to be honest, but I think think a lot of people think now that the court is so polarized, it's not such a mystery as to how the court's going to vote in some sense. I can talk about why oral argument I think still matters and is informative in that context during Q&A if you like. Yeah. All right, so what's the Chief Justice? This is a much shorter topic, so we will get to question 3, I promise. What's the Chief Justice doing about it? So I think possibly here I had some sound. I can't remember. I was just looking at this morning, but jet lag. Can't remember if there's sound on these ones. If you want to change it over, or they're very short. They're not like the long ones. Oh, here we are. So this is one of the things. This is what we say in the first article. There could be better enforcement by the Chief Justice. That's what we called for. And so then we decided, okay, well, let's code if the Chief Justice is doing it. Now, this is a project I'm only going to do once because it was hugely involved. Unlike interruptions, which are so easy to code because they're all in the transcript, here we had to do much more detailed content analysis. And it was really, you want to make sure you're getting it right. So there was a lot of checking. So it's pretty tedious. And so what we did is we looked for some of the intervention techniques that we had come to recognize, but it's certainly not capturing everything. There's probably lots of types of interventions that we don't capture. We just had to look for certain things that we wanted to make sure that the ones we were capturing, we were pretty sure were interventions. So here's some examples: naming and justice. Right, so you hear the Chief Justice, Justice Ginsburg's being interrupted by the advocate, and then Justice Kagan attempts to jump in as well. And the chief says, Justice Ginsburg, he says, whose turn it is to speak. So it's as simple as that. So one of the things we did is we went through and looked at every time the Chief Justice names a justice. Sometimes he'll name a justice and he'll be saying, oh, Justice Ginsburg asked a really interesting question earlier that I want to get back to. That's not an intervention. So we had to actually substantively check each one, which was pretty tedious. But we did find a bunch where clearly he's shepherding the nature of the oral argument. Okay, what are some other examples?
I'm sorry. The regulation here.
So here you can see Chief Justice is actually shepherding the argument in response to his own interruption, but so something like please follow up, please go ahead, right? We looked for those sorts of terms, but go ahead, for example, we also saw examples of said, for example, well, asking an advocate, well, what if your client said to you, go ahead and do this, right? And so it can be substantive as well. So we had to differentiate those. Oh, actually, here's an example. So that's an example of something that's not an intervention, right? It's just within the middle of the text. Whereas here, another example, and then later in the same argument. So this is an example of how tedious the work was. Like within this one argument, there are three uses of the term go ahead, and only one of them is an intervention, right? Okay, so, but what do we see? That's enough preliminaries. What does the data actually show? So here we see, even going back into the Rehnquist era, so Chief Justice Roberts became Chief Justice in 2005 term, there were really very few interventions by the Chief Justice. And then gradually over time, he starts intervening more and more, with the exception, of course, of 2020, right? Maybe a little drop off, but overall, the trend is definitely upward. Okay, so, and that just breaks it down by era. Once again, we have the same problem of averaging out 2020. This was, somebody asked me a question earlier about who interrupts more than this gets to the question. So here we are, who does the most interrupting and being interrupted? So this is what we call net interrupter. And so that is looking at who does the most, everyone to the right of the bar of this line. If you're to the right, that means you interrupt more than you are interrupted, and everyone to the left is interrupted more. You'll see down the bottom, Justice Sotomayor is interrupted a huge amount, much more than she interrupts. Justice Kennedy, on the other hand, is the #1 interrupter because he thought he was so important because he was the center of the court, right? Compare that to on whose behalf the Chief Justice is stepping in to give them the floor. Overwhelmingly, Chief Justice Alito. ideological brethren to a certain extent. Not that Justice Alito appreciates it. He apparently hates Chief Justice Roberts because he thinks he got his job. But if you compare, look at the number one interrupters like Kennedy, Scalia, Stevens, etc., are up here as the people who are receiving the interventions by the chief. So that seems strange. Whereas Sotomayor isn't down the bottom, but she's a lot lower, even though she's being interrupted so much. Justice Kavanaugh, who's the next most interrupted, is basically at 0. And so looking at it that way, by individuals, it seems that the Chief Justice is not addressing the problem at all. But we actually have more good news on this front. Despite the fact that overwhelmingly he's intervening to say, poor old Justice Alito can't stand up for himself and I need to intervene on his behalf. Nonetheless, keep that in mind when we show you the results.
I'm not sure I understand on the right side, Gorsuch, why is there going into the negative? I'm not sure.
Because he's more often has the floor taken away from him to give it to the person he might have interrupted.
By the Chief Justice?
By the Chief Justice, yeah.
And Thomas doesn't do much there.
Thomas doesn't do much, but what we'll see in the next topic is that even though Justice Thomas barely ever used to speak, we still see the same patterns of behavior in his, few words every year compared to the many, many words of some of the other justices. All right, so let's look at gender. We know that women are being overwhelmingly interrupted in the 2000s onward, right? Again, and increasingly so. Well, what do we see? Starting off in 2003, when the problem really started, we actually see the reverse. The Chief Justice is intervening on behalf of men, giving the floor to men at first more than he's giving it to women. But gradually over time it changes. And now, and I'll show you how we test this for statistical significance, it's quite large. He's overwhelmingly intervening on behalf of women, even at the same time as favoring Justice Alito. So if it wasn't for Justice Alito, the black line would be down here because most of his interventions for men are for Justice Alito. But overwhelmingly, he's still intervening for women. This is actually looking at whether the person, what we call the winner, the person who's receiving the intervention, was the person who's interrupted. Very high correlation. Whether they were the person who was interrupted and female, even more substantively significant, right? So this is saying he is intervening on the part of the person who was interrupted. He's getting it right most of the time. He's particularly doing it for women, right, over men. The people who he's intervening against were the person who is interrupting, except he's not actually doing it. He's not being as strict when women interrupt, is what that's showing. So, Chief Justice Roberts, feminist icon. I've written a lot of articles where I criticize Chief Justice Roberts, and so I think it's only fair to give him his dues when they are deserved.
Are these justice to justice or advocate?
Yes, these are just justice to justice because we could look at that as well, but it's just such an involved process. Okay, we don't need to go through all the summary. All right, and so that's the interventions essentially. So Justice Sotomayor made 2 claims. One, that things have really improved. At the justice to justice level, unfortunately, that's not true. We do see some sign of improvement in terms of the advocate behavior. The advocates aren't interrupting the female justices so much anymore, but whether that holds in future years, we shall see, but the evidence is good. And the Chief Justice is intervening more. I still think he could do it a lot more. Like the raw numbers, the percentage of times he intervenes compared to the number of interruptions is still low. I don't want him intervening all the time. One of the things I love about oral argument is the flow of it, the dynamism, the fact that people are jumping in and pushing different questions in different areas. And so I wouldn't want to see that interfered with too much. I do think he could be doing more than he is. And the interesting thing is, I don't have a recording of this, but he was actually asked, are you doing this? And he said, no. He said he gives the floor to the most senior person. So we tested that and it's not true. So I don't know if he knows what he's doing and just doesn't want to admit it because it sounds a bit woke, or if he doesn't even know that he's doing it. But who knows? I can't get inside his mind. I can only look at his behavior, but it's interesting. Mm-hmm. Any questions on that before we go on to question number 3? I promised we'd get to it. All right. Judicial advocacy. I do have some more embedded here. Is that okay? Or I can...
Yeah.
They're pretty short.
So it's not the and when there is a day of election, isn't that
Basically, it is that.
So did you hear what was happening there? The advocate was struggling a little bit, and Justice Sotomayor steps in to help and says, so what you're saying is this, right? And one day is enough to satisfy that threshold, right? Yes, yes. And so she's helping the advocate and essentially giving him the answer. And so we see a lot of this advocating on behalf of an advocate who's struggling a little bit. We see the opposite as well, where we see justices, you know, giving a much harder time to the advocate who they're going to vote against. And so we can actually, even though oral argument comes well before the decision in the case, we can predict how they're going to vote based on who they direct not only questions to, but comments to. So that's what I'm going to show you. So we see a lot of not just questions being asked, but oh yeah, this is a great. So this is an unusual admission by the justices. There's some advocacy going on. It's actually pretty quick, so see if you can catch it.
Discuss one day, this is a punishment. One day, I'm sorry, you want me to tell me?
It's really hard to hear, even in the room. So what happens in this case is the male advocate gets Justice Kagan and Justice Sotomayor confused. And he refers to Justice, as I was discussing with Justice Kagan before, but we heard he was discussing it with Justice Sotomayor. This happened, they don't look alike. And they sound very different as well. And Justice Kagan steps in and she says, no, Justice Sotomayor was the one who was helping you. I'm the one who's not, right? That's like, in judicial terms, you'll have to trust me, I'll show you the transcript. In judicial terms, this is like an acknowledgement, like Justice Sotomayor was getting in there and doing advocacy on behalf of the side that she supports. Yeah, it is a little hard to hear because she speaks it so quickly. Okay, so this is what we're going to look into, this kind of advocacy, and can we actually measure it? And we have to sort of figure out ways to measure that because there's no advocacy index, right? We have to create it. Okay, the first thing we look at is silence. So each of these dots are a year in which a justice has been silent and not made any comments at oral argument. And as you can see, that used to be fairly common in 1960, and it's decreased significantly. Now, I was writing this in 2017. The data goes up to the 2015 term. I was writing this in 2016. And so it's a bit different now. But Justice Thomas is up here as being silent in many entire terms. And he's unusual. But ignoring Justice Thomas, and there's interesting things to say about what's going on there, but overwhelmingly what this graph shows is this whole absence here, that this has changed. There's no longer the case that justices don't ask questions, that they don't engage. It used to be an oral argument is just different now. And I want to explore the ways in which it's different and what the justices are doing differently. Okay, so judicial activity over time. We've broken this down into 3 eras, which I can, this is essentially because oral argument used to be 2 hours instead of 1 hour. So we do a check there to see if that's when things really changed. And then 1995 is our theory, essentially. That's when politics really started becoming much more measurably polarized. And I'll show you a graph on why that's the case. There was signs of polarization earlier than that, starting in the 1970s. But if you remember Newt Gingrich and the Republican Revolution in 1994, when this huge number of junior congressmen came in, they're like, I don't want to wait 30 years to be a chair. We're going to throw out all of the norms of Congress and we're going to start just changing the rules, essentially. And so we saw what happened there. We saw a lot of polarization starting to happen between the parties. And we see this, what I want to see is what happens at the court starting in around 1995. And what we see at the court is, in terms of the number of words per case, here we have the advocate, here we have the justices, sorry, and here we have the advocates. The advocates have always spoken more than the justices. The distance is very small now. There's been this huge increase in how much the justices speak and this was when it was still 60 minutes. So it really was zero-sum game. Every word spoken by the justice is taking time from the advocate. And so we see this jump, and we see it even better. No. And so in a 60-minute oral argument, the effect in the modern era from 1995, compare them, is 13 additional minutes by justices speaking. So almost a quarter more additional time by the justices compared to what they used to be speaking. Right? What are they doing with all those extra words is the next question. Okay, interruptions, this is just showing what we've already talked about. We won't spend time, the increase in interruptions, but it really starts being statistically significantly different starting around 1995. It's not that the cases are changing, there's actually fewer cases, so it's not that, you know, something about the cases. Okay, what happened? This is a bit of a complicated slide, and this is not mine. This is, as I mentioned, political scientists have shown this work. But if you look at the poll, this is, one is for the House and one is for the Senate. So essentially showing the same thing. But if you look at the number of moderates in each house, massively declining, right? We just don't have moderate senators and House members anymore, right? Huge decrease. At the same time, the polarization, like if you look at the ideological means between the parties, massive increase, right? And so pinning down the particularly, you can see that there was some in, you know, even in the late 70s, there was an increase. But in 1995, we see this huge, is that a hand? Yeah.
Yeah. Go back to the previous slide.
Sure.
Second.
That one? That one?
One about showing the number of cases that they're talking
Oh,
about.
yes. Yeah. That's the number of cases. It's gone down even more since then.
Yeah. This is the one. Yeah. I mean, could you give us an account of that? I mean, 175 are up to close to 200 versus 75 roughly.
The short answer is it's nice to be a Supreme Court justice. I've actually written on this. I think that we could force the justices to do more work. They only work between June and October, between October and June, sorry. And they have 4 clerks each to handle now an average of about 55 cases. So they split up the opinions. So divide that by 9 and you get how many majority opinions each justice is responsible for. It's a nice life. And meanwhile, there are, you know, major issues of law that have not been decided, like essentially jurisdiction issues relating to the internet, for example, still not decided. Like they're not doing a lot of work. Yeah, they're just doing less and less. And I think it's partly conservative, even though the Supreme Court is very activist in terms of its political effect. I think we would all agree. In terms of part of the conservative philosophy, and the conservatives have dominated the court, is to decrease the power of the judiciary over time, right, as a check on government. And one of the ways in which they do that is by just deciding fewer issues. So I think that's what's going on there. I talk in the paper, I can't remember exactly like why I feel like this is sort of showing that it's not like, I mean, you could say, well, they've got fewer cases now so they can talk more, but they don't have extra time. So, okay. So we see this huge amount of political polarization. So my theory going into this is starting around 1995, we should be seeing this change. And we can talk about whether there are other things changing at the court at the same time, or whether it could be something else that happens to be the same. And we looked into that a lot. I'll take that in questions unless you want me to talk about it now. Okay, so what do we see? Now I want to look, okay, that's all been background. Now let's talk about how do we measure judicial advocacy? So if you go to the Supreme Court website, it says, what's the point of oral argument? The point of oral argument is a chance for the Supreme Court justices to ask the advocates questions that help them decide cases. And we're like, okay, well, is that true? And is that changing? So we looked at how many questions the Supreme Court justices are asked. What are they doing with their additional 13 minutes every 60-minute argument? The answer is not asking any more questions. The number of questions in the black has stayed exactly the same over time. Those 13 minutes are not being used to pursue the stated goal of oral argument of asking questions. They are being used to make comments, right? The perfect tracking between the additional time and what they're using it for is the difference between questions and comments. So if you think about, and it doesn't matter how you define a comment. Like if you want to be the most generous you can be and say an entire speech episode, which sometimes can take up a whole page, if there's one question mark in that entire thing, will count it as a question. You still see the same effect. Or if you count the number of questions versus the question marks versus the number of periods, same thing, right? They are not asking more questions. They are taking up almost quarter more of the time, and they're just using it to make comments to the advocates, right? They're supposed to be trying to, you know, have questions answered to decide how they should decide these cases. They're coming in with ideas, telling the advocates what they should be doing. Now, in terms of one of the alternative theories about, you ask people what changed oral argument. Everybody agrees oral arguments changed, but people have these theories. And the most popular one is that Justice Scalia changed the court. Now, I don't like big men in history theories because they're usually men, first of all, but it's usually not. Like, it's usually a really easy answer to point at a particular person. And in all of this, so Justice Scalia joined the court in 1986, and all of our effects really take off in 1995 or thereabouts. There's one exception. When did comments start coming out? About 1986. So if Justice Scalia is responsible for anything, he's responsible for this one shift towards judicial advocacy of making comments more than questions. So I don't think that shows that he changed the oral argument to be more dynamic. He changed it, if anything, to be more advocacy. All right. What else? How else can we measure advocacy? We call this advocating for friends versus foes. So essentially, if you are a Supreme Court justice, what are you going to do with your time to ask questions or make comments, as the case may be? Are you going to, and in fact, so when Justice Sotomayor was first appointed to the bench, she came, I used to be at Northwestern Law School, and she came and gave a talk, and I asked her in a public forum, I said, what are you doing at oral argument, you know, when you're asking questions? And she said, well, I come in with, you know, an idea how I'm going to vote based on the briefs, but I want to be sure, and I want to, you know, really ask tough questions to figure out I'm voting the right way. And I ask, so therefore I want to ask really probing questions of the advocate whose side I think I'm going to support. And I was just like, okay, I don't think that's true. And I went away and started looking at the data. And the next year, Justice Kagan was appointed to the court, and she came, and I asked her this question, but I said, I asked Justice Sotomayor this question, and this is what she said, and I don't think it's backed up by the data. And that's when Justice Kagan gave me the explanation that I gave you earlier about she's trying to influence her colleagues because she doesn't get a chance to, because she's the most junior justice. And that is what's going on here, I think, maybe. But also I said, well, if I'm right in my preliminary look at the data, what they're doing, and this is what we show here, is that you can predict which way a justice is going to vote by who they talk to the most, whose time, which advocate they're addressing. But it's not the advocate they're going to vote for, it's the advocate they're going to vote against. So let's look at this. We've seen this over time. This has always been the case. The number of words spoken to the advocate that the justice 6 months later votes against the argument they're making has always been more than the, so Justice Sotomayor's theory has never been true. But since 1995, ooh, look at that jump, look at that gap. And it's only increasing. People talk to the person who they're going to vote against. They give a hard time to the person they're going to vote against. And what's interesting, as I mentioned about the Australia case, we all interpreted this as saying, well, you know, you've only got so much time. You're using up the time of the advocate who you're going to vote against because you don't like them. When we go to Australia and you have days and days and days of oral argument, there's no limit. In fact, the time is agreed between the advocates and the justices. We still see the same effect. So it's not about the time limit. It's just people argue, especially lawyers, argue with the people they disagree with, right? So it's not about, it's actually not as strategic as I thought in terms of using up time, but it is showing you can predict, you can just count the number of words spoken in each half. Sometimes the advocates, the justices don't even say anything during the time of the advocate that they end up voting for. Because they don't need to challenge them at all. Yeah.
But why don't you think that's not strategic? I mean, maybe they're wanting to show how bad the argument is or how bad their case is.
Oh, that's right.
So they're bringing that out.
It is absolutely strategic. And this is evidence of, you know, advocacy, which is a type of strategy. I was just saying it wasn't as strategic as I thought. I thought that they were deliberately trying to use their time so they didn't get a chance to convince people, but it's not, they're not doing that. The Australian example suggests they're not doing that, but they're absolutely doing strategy, just not quite 100% as strategic as I thought it was in terms of using up deliberate sort of not letting them be heard. It's just that they're arguing with them. And I think they are doing, I think, you know, in Justice Kagan's word, they're trying to point out the reason Justice Kagan spends her time trying to pin down the advocate whose argument she disagrees with is to show that her colleagues, even now, and this is why I think oral argument is still important, she might not be able to ever convince, you know, Justice Alito or any of the conservatives like to change their vote on like abortion, right? But she can change how they write the opinion, right? How broad the decision is, whether they set up a test that's obviously flawed and going to lead to really big problems in the law, right? She's trying to influence that. And so, yeah, no, I think it's absolutely strategy. She's asking questions directed, pointing out all the flaws in the arguments of the person who she disagrees. I should say I have no idea how long I've been speaking. How long?
Pretty close to an hour.
Close to an hour. Okay. All right. Yes, please.
I guess you're not gonna have time to talk about the comparison with Australia, but for this type of analysis here, is there any kind of trend or trend break in terms of advocacy versus the questioning?
No, and in fact, if you put the two key tests of advocacy are the questions versus comments and the friends versus foe. And if you put them together, I can't show this graphically because you have to do this in multivariate regression. But essentially, if you look at who the justice is speaking to, they end up asking questions of the person they vote for and making comments towards the person they vote against. So it's actually more stark than these graphs show. I can show it in the numbers. The change over time, I don't think there's been any, I haven't like redone this analysis recently, but I don't think there's been any decrease. I think it's only getting more strategic.
But would you say that Australia has become much more polarized politically?
No, not really, not to the same extent. And I think partly that's the voting system, like the preferential voting system, but it's also we have compulsory voting. And so you have to appeal to the middle. Whereas here, you have to, like, it's all the extremists have all the power, right? Especially since primaries were instituted. You know, starting in 1968, the great increase of the primaries. That's why in the late 70s, we start seeing this effect because people who vote in primaries are much more extreme. And then, you know, so over time, we've seen this diminishment of the middle.
I think it was before the pandemic, I heard Nina Totenberg on NPR talking about oral arguments in a case. And she said, this is her words, that you can never predict, based on the oral arguments, how the court is going to vote. You seem to be saying quite the opposite. And when you hear something where they haven't voted already, and you analyze the oral arguments, how strongly are you sure you can tell which way the court is going to go based on your analyses?
Mid 80%, we get it right. Yeah. Yeah. So you can't predict like every single vote in every case, but overwhelmingly you can predict it. It's just like Nina would be out of a job if it was 100%, right? You know, her commentary, like you wouldn't need it, like you could do it all mathematically. And so it's in her interest to say that, but yeah, overwhelming. And in fact, after we did this project, we set up a website where we just automatically outputted predictions on those cases. And we were like, we did not get everyone right, but about 83%, something like that, as I recall. Yeah.
Could your analysis be distorted by the content of the argument, the case? In other words, there's a wholly different point of view on tax as opposed to Second Amendment. That, you know,
yeah.
Or...
So we're looking at sort of overall looking at all the cases together. There are definitely some areas that I think are easier to predict than others, right? You know, affirmative action, you know, the church cases, religion case, First Amendment religion cases, etc., that are just much more polarized. Like people talk about the boring cases like tax and so on, though tax people will disagree and say they're not boring at all. I will say that the effect of sort of ideology generally has been studied in all areas. And, there's a study specifically on ideology in tax and show it is predictable in the same way. So I did a study on intellectual property because there was a theory that intellectual property cases weren't ideological, and showed essentially that they were, but they were less ideological. And then we looked at it again 20 years later, 15 years later, and it's actually, they're not ideological now, which is interesting. Like it's the one area where, the court seems to be less political. And the explanation we give is essentially there you've got the federal circuit deciding case, and the Supreme Court's mostly just correcting the federal circuit getting too big for its britches. But generally most areas, I think there's definitely more and less salient cases and areas. And one of the things I'm working on at the moment is to come up with a better measure of case salience so we could put that in as a control. We do put in controls for case salience, but they're incomplete measures. So look out for that. Yeah.
Has there been any study of the number of words per minute? I've noticed, it seems to me that speaking has speeded up significantly in the last decade or two.
Yeah, the only study I know of that really looks at that, I think, is our study on the pandemic and just showed how much, because they spoke so much slower in the telephonic arguments, because they were bored as well, because it was not dynamic and interesting. And that's generally people don't use speed, but that is one area where we showed like there was a distinct drop in speed during the pandemic, but I think it's gone back up again because it's more competitive, right? Yeah.
It seems to me a younger generation speaks much more quickly than my generation did.
Yeah. Well, one of the projects that we're doing, we've got preliminary data on, is looking at a sort of related, I think it's a related question, is complexity of speech. And so our argument is, our sort of hypothesis going in and our preliminary data, so preliminary, is that language at oral argument has become simpler since they started having OIA, essentially. People like Nina Totenberg started, doing these pieces on what happened at oral argument. And it's more a sort of a PR effect of the court. They're trying to, let the common people understand what great things they're doing by speaking more simply. And my hypothesis, which we haven't tested yet, we're going to compare oral argument to the opinions, and that the opinions, I think, are going to be just as complex as they ever were. And you'll see this disconnect, this increasing disconnect between the performative nature of oral argument and then the actual work product of opinions. But to be fully determined for that, it's sort of like, it's not exactly on your point, but it's sort of a similar, like looking at those sort of trends over time. Yes, please.
Well, I'm sort of curious about laughter.
Oh, yeah.
You said that was one of your favorite topics. That's something I've never considered in thinking about the Supreme Court.
Let me show you. I'm happy to go into more detail, but so a lot of people used to talk about, oh, look at Justice Scalia, he's so funny, and Justice Breyer is the second funniest, and they're the two that got all the attention, because if you look on the left, the number of laughs per oral argument, right? Now we can do exactly the same analysis that we did with the friend and foe in terms of how many words you spoke, but look at who you make fun of, essentially. When are the laughs coming? Are they coming during the time of the advocate you vote for or the advocate you vote against? And I bet you can guess the answer. It's the advocate you vote against. They are making jokes. The justices are making jokes during the time of the advocate that they don't like their side. And look, who's got the biggest gap in terms of jokes made to the advocate they vote for versus against? That gap, highest for Justice Breyer and Justice Scalia. Rehnquist is high up there as well. He was fourth over there. The only person that's not true of is Chief Justice Roberts, who's all the way down here, and he was in third place there. And I think he's sort of, the institutionalist who's making jokes sort of more about, the light bulbs turning off in the courtroom, etc. And so Thomas is this almost empty bar down the bottom. Yeah. Not funny and doesn't talk a lot either. And when he does talk. But so essentially this is showing, and I can show you more graphs if you're interested, that this is the same kind of it's another form of advocacy. You can actually predict outcomes based on, you can predict justice votes on terms of who they're making fun of. Another effect, if you bear with me, is, oh yeah, so this is the number of laughs. This is the same point about the performative nature of oral argument. I think part of it is that, like, the number of jokes have just increased massively, but we show that if you look at the number of jokes being directed at inexperienced advocates compared to experienced advocates, right? And so this isn't a great equalizing force. This is just being mean to the people who aren't as, you know, part of the boys' club of the Supreme Court bar. But also, so this is everything below the line is essentially showing this strategic behavior. So this is how the justice, the same point about, you know, voting for and against your friends, but here it's making fun of them. So everything below the line, which is increasing, is essentially the distance, the predictability of whose the jokes are being made to is increasing. That's for how the justice votes, but also how the court as a whole votes. So they're making fun of advocates who are losing, who've lost their own vote, and also who are losing before the court. So they're making fun of people they disagree with, people who are inexperienced, and people who are losing. So not a great equalizing force. Yes, please.
Are you able to distinguish between nervous laughter and sort of advocate laughter?
No, we do come up with different categories of laughter and we try and put them in. So what we did this, as you can see, going all the way back to 1955, just based on the statistics, because the very nice people who write the transcripts at the court put in brackets laughter, which was very easy to code, except we had to take out all of the references to slaughter and manslaughter because that contains laughter and is not very funny. But what we do is we take 10 years to just study in depth qualitatively. And so we read the paragraph before, during, and after every laughter incident at the court over 10 years. This was actually a project we did while we were traveling. We lived in Chicago. It was very, very cold and snowy, and we measured it a number of winters. And my husband and I did this project together, and we decided we wanted to move to the Southeast. And so we spent a month traveling around the Southeast and fell in love with it, and that was when we decided we wanted to move to Atlanta and come to Emory. And while we did this, every evening we would sit and read the laughter transcripts and read out the funny ones to each other. And I think it just put us in such a good mood that we fell in love with Atlanta. But we did look at we looked at it substantively as well. And we did come up with different categories. Nervous wasn't one of them, but there were things like self-effacing jokes. The only justices who do that significant amount of time is Justice Breyer and Justice Kagan. Everybody else, like Justice Scalia, the so-called funniest justice, every single one of his jokes is about, I am dominant over you. That is the nature of the joke. And they're not fun. A lot of them, like Justice Kennedy occasionally has witticisms where he once made a theory of relativity joke, which was pretty clever. But most of the jokes are about, I have power over you. And a lot of the laughter is nervous, like kind of, it's this discomforted laughter in the courtroom of, oh, this is uncomfortable. It's not really very funny at all. It's strategy. Yeah. Yes.
So if I had a case coming before the court and I'm going to hire an advocate, could you use your analyses to tell me a profile of the advocate I should be looking at?
White, male, and part of the regular Supreme Court bar who's the most experienced, unfortunately.
No, that's kind of what it sounded like.
Yeah. Like if you're being, if you're actually just trying to win rather than, yeah. Yeah.
Is there any evidence that any of the justices have joke writers?
Because they'd be funnier if they
So maybe this is a comment, but you have a lot of experience. I'd like your opinion. Since Trump got elected, the Democrats said the courts are going to save us. And now more recently, I've heard, no, it's going to be people in the street. It's going to be grassroots. But I'm just wondering, whatever, just your opinion, are they going to follow the Constitution when that's where it's at now? He's not listening to district judges, but if a case comes to them, are they going to just follow the Constitution?
They being the justices, not the administration.
Yeah, the justices.
I mean, yeah, I think just some justices more than others. I think they will, but if the court is, so I got a question before we started about the law firms, the attacks on the law firms. And I think this is hugely important because if law firms are scared off from representing people who disagree with the administration, then how are the courts going to save us? You can't get representation, right? And so a lot of, there's still going to be people bringing cases, but, you know, some of the best, you know, I was just asked, you know, who you should hire. Well, the best guns for hire might not be for hire for the people who are going to challenge the administration. So it's going to be harder to make a good argument. You know, I do think that the Supreme Court justices, some of them are going to stand firm on some of the issues. But, you know, is the administration going to follow those, you know, pronouncements? Like they're already disobeying Supreme Court decisions as well. Like, you know, bringing this fellow back from El Salvador was part of the order of the court, and to, you know, to make all efforts. And do you think they're making all efforts? No. So I do think it's going to be hard for the courts to save us from illegality. Yeah, it was amazing to me, like some of the decisions that came out, like the you know, whether Trump was eligible to run. I think there was a very strong argument that he was not. And you know, I think the Supreme Court, like it was showing to me some of the lengths that some of the justices would go to support him, because it's not going to be an administration that gives greater power to the Supreme Court. The Supreme Court is going to be weakened by this administration because this administration is not about the rule of law. Whatever you think of it, like whether you think the ends justify the means or whatever, like it's not going to be done in a way that's, you know, crossing T's, dotting I's. So I found that some of the knee-jerk support for the arguments made by the Trump administration, by some of the justices, even if he's your guy, if you care about the law and all of your prestige and status is based on your role as the head of the law, I don't see why he's the guy for you. But yes, they knew better. Yeah.
Justice Barrett is because first stance on abortion. Do you think he Trump made a mistake for himself in his choice of her?
Because she has opposed him on some things.
Just because she does have a moral compass somewhere in there.
Yeah. Yeah, I mean, so most people, so I've done studies looking at how much the Supreme Court behavior is ideologically predictable and how much is something else, which I think looks like law. And what I've shown, so most accounts, like if you see these arrays of the court in, you know, the New York Times and so on, that's just pure left to right politics. Now, I believe as a political scientist that politics is hugely influential on the court. That's what I've been showing you. But I do think that the law matters as well to most people who are trained in the law. Part of what we do at law school is professionalize people in believing in a system of the law. Now it's malleable. You can always make arguments on both sides. But I did a study some years back, so maybe it's changed, but looking at is there a second dimension of decision-making on the court? And I showed, yes, there is a significant second dimension. And it looks a lot like formalism, pragmatism in terms of judicial methodology. And so interestingly, Justice Ginsburg and Justice Scalia, who are very far apart left-right, actually very similar on that y-axis, because they're both very formalist. Right. So Justice Ginsburg, you know, she made her name arguing, for example, that gender discrimination suits can be brought on behalf of men as well as women. Like that's a very formalist position. And so I think the law does influence all justices to some extent or other. I think Justice Alito and Justice Thomas seem to have left some of that behind. Like I think, you know, Justice Gorsuch, Justice Barrett, Justice Kavanaugh, Chief Justice Roberts, they are 4 conservatives who will vote either way, depending on what persuades them. I feel like Justice Alito and Justice Thomas have kind of drunk the Kool-Aid, as evidenced by, you know, Justice Alito literally flying the flag, right? And so would Trump have been better off finding a mini younger Alito instead of a Barrett. I mean, there were different pressures. They were under very significant time pressure apart from anything else. They had to get it done before the election, because Justice Ginsburg had just died. I think, she's overwhelmingly, mostly, in support of the positions he advocated for. But I do think she will stand up to him sometimes. But whether that will be effective.
Well, I noticed for the justices, you rank them conservative or liberal, and that has sort of an equivalency sound. My bias is that the liberals are not sort of equivalently liberal compared to the conservatives, but that's totally a biased opinion. I mean, is there any way of sort of measuring that?
I share your view. I think that what we have is moderate liberals and then an array of conservatives. How we measure, the way that we traditionally, political scientists measure like degree of liberalism, conservatism is to ask survey questions about their views, and then you can compare them. We can't do that with the justices. We can just sort of get impressions of, how they vote in cases and the opinions that they write. So it's hard to measure it. But certainly if you look at, Justice Douglas and Justice Brennan and, the liberals of old, like they're just not comparable to the liberals on the court now. So I think you're right, but I don't know how to measure it. Yeah.
I wonder if you could talk a little bit about the constitutional crisis issue in the following sense. As I understand it, if the Supreme Court makes a decision and the Trump administration refuses to implement it, and not just that they keep on dragging it out and coming up with excuses, but they just won't do it, then somebody can be held in contempt, right? And I don't know if that would be government lawyers, attorney general, who that would be held in contempt. But suppose that a contempt order comes out from the Supreme Court and it has to be enforced. And as I understand it, it's the U.S. Marshal that has to enforce the contempt. And as I understand it, Pam Bondi could say, don't enforce that.
Yeah.
Is that correct?
Yeah. So, I mean, at the district court level, there's usually, somebody in the court who could literally take someone, like the bailiff, who could take someone temporarily to jail. But if you order, so if the Supreme Court's like, you're not answering, we keep seeing cases where the government keeps refusing to answer the question and saying, I don't have the answer to that. And it's like, well, the judge gets very frustrated and says, I told you to come prepared to answer that question, come back again. Like, they're very reluctant to hold a government official or a lawyer in contempt of court in that circumstance, but maybe they will get pushed to that point. But there is part of the reason they're reluctant is that they don't want to be the catalyst for the constitutional crisis of having that disobeyed. But if they're like, okay, send the attorney general in, or the solicitor general or whoever, to come and actually answer these questions, and then Bondi says no, like, are they really going to send the marshals after Bondi, and then Bondi's going to order them down? I mean, I just think the court's going to avoid that. And so I don't think it's going to come to a head in that way. But, we saw this, we've seen this with, if we go back in time to look at circumstances where the Supreme Court ordered state government officials to do things like to have enough beds in prisons and to improve the amount of money going to schools to deal with, segregation. Exactly. And so they had these specific orders where the court would say, there were cases where the court said, you have to pass a new tax to raise the money, because the state would come and say, we don't have the money to pay for these schools to be improved. And there were cases where the court ordered states to levy taxes. But the problem there is, like, they were just dealing with a particular state, not the federal government. And it's much harder when you're battling the federal government.
But how would the court enforce such a ruling?
Yeah, probably they can't. Like, I think eventually we might get to the point where there's outright disobedience.
That's what I'm
and the Supreme Court, and that is
worried about.
Yeah, well, we're not so far from it already. Like we're already having disobedience, but there's just a little bit of everybody's pretending that it hasn't exactly happened already, even though it kind of is.
But there's no role for Congress here, the third branch, there's no
I mean,
role for them?
The Congress could act, will Congress act? But, yeah, you've been waiting for.
This calls for speculation on your part, but is there any idea that any of the justices are having second thoughts about having made him a king?
I mean, I think the justices who didn't want him to be a king in the first place definitely are not happy about it. You know, they don't like to, you know, make public comments on that, but I'm sure I would be surprised if they, but I mean, this is the one thing you've got to say about Trump is he did tell us what he was going to do. He is doing what he said he was going to do. People didn't believe him, but
But now he's not the least bit afraid of criminal liability.
You know what?
He can attribute everything he does to some executive presidential authority.
I mean, an argument is that the whole reason he ran again was because he was afraid of criminal liability before. Now is he? I don't think so. I mean, he's already talking about his third term. So, you know, and as long as he's in power, the Supreme Court said he's immune from prosecution. So, yeah, we've strayed a little, but that's okay. I'm happy to chat about anything. Yeah.
So I know they were you know, if it's a nonprofit organization, whatever, when they talk about it, terms for the Supreme Justice, the justices and stuff. I'm wondering, do these groups also consider the thing of the caseload? Because I never heard of that. Like, is someone advocating that they should be working harder? Just like people come up with, you should have term limits.
I wrote an op-ed essentially saying that the justices should be so a lot of the Supreme Court reforms that people talk about require constitutional change, and that's hard. So I think we're better off thinking, how can we change things in a way that's within the constitutional system that only requires legislation? And one of the things I proposed is, you know, people were talking about packing the court when Biden came into office, and they were talking about, they were just coming up with random numbers that would basically just get them a majority. And I'm like, okay, no, let's see this as an opportunity to think about how we should actually change the court in the process, not just for partisan advantage, but for institutional betterment. And so I wrote an op-ed arguing that we should have actually 15 Supreme Court justices, and they should sit in panels of 3 panels of 5. And then the court as a whole can vote to review those panel decisions in any given case. And what that would mean is that they could hear a lot more cases. They wouldn't be hearing 55 cases a year. We could actually change the Judiciary Act to make certain things compulsory to take. And so they'd be deciding more nuts and bolts law, and not just, you know, should we have abortion, and doing like lawyer job, not just political jobs, but also would make them potentially reviewable. And I think that there's a lot of social science analysis showing that judges generally behave differently when they're going to be called out on, like when somebody's going to be overseeing what they do. Like if there's, so, you know, if you've got a panel of 2 Democrats and 1 Republican, or vice versa, compared to 3-0, the decisions look different, even though you've got a majority in each case, because you've got someone there to say, hey, you're not following the law, right? And so same kind of thing. If we had the Supreme Court sitting all together, would review the panels, then the panels, I think, would moderate. And so it'd be a way of forcing moderation a little bit more in an era of polarization. But, you know, I wrote that up, I got a bit of attention. That's it. Like there's not been a groundswell of talk about changing the Judiciary Act rather than, you know, having, now it'd be great to have terms. Like, yeah, we don't want, you know, people who've been on the court for 40 years. We don't want people being chosen based on how young they are, and that so that they can serve for 40 years. Like it messes up our incentives. And so terms would be great. The only concern is, okay, what do justices do after they retire? If they're young enough, like, is there going to be the same problem we see in Congress, where we see legislation being passed, you know, by people who are then going to go and work for the organizations that are benefiting from that legislation? Same thing for the court. But I think that's not as much of a problem as the current situation, where people are on the court and they're completely out of touch. They've been on the court for so long. They only talk to other people who are like them. So yeah.
I have 2 questions on Justice Jackson in particular. So something I've noticed, especially this term, she talks a lot more than some of the other justices. Is there a correlation between more junior justices talking more than more senior justices for kind of the reason that you were talking about, kind of persuade the other justices for getting votes? And then something else, this is not based on that, but just my personal observations. It seems like Justice Jackson in particular uses a lot of almost self-deprecatory language of saying something like, I'm confused by X, or I'm trying to figure out X, can you explain it? Is that something that you've, I guess, studied at all? And if so, is that potentially fall along the line of the male-female differentials that you were talking about, or is that maybe a seniority junior distinction?
Right. So in terms of the first question, and forgive me if I forget the second question because I am like, so I remember it now, but in terms of the first question, no, junior justices don't talk more. I think what that is an illustration of is what we call the losers of history. So people, actually I've got a slide for this. I've got a slide for, so generally people talk more when they're on the losing side of a given case. So let me see if I can find the slide. While I jump around. Too many things on. Yeah. I was just going to. Maybe this isn't worth it. Here we are. So, if you're in the minority, if you're dissenting, if you end up dissenting, sorry, when the opinion comes down, you talk, well, since 1995, significantly more than when you're in the winning side, right? So you're trying harder to convince people, and the people who are pretty sure they're winning can sit back and not do as much work. The same is true in terms of history, and I can actually show you this in the Australian context, so it's really nicely illustrated. I can show you the same thing at the Supreme Court, but oh yeah, so that's the same thing in Australia, but we see it by era. There it was, in fact, you were right. Okay, so losers of history, we call this. So remember I mentioned to you that conservatives interrupt more and liberals interrupt less and are interrupted more. We see the same thing in terms of the amount of speaking. So since 1995, when things have become, before it was kind of like non-differentiable, right? Those crossed lines mean basically zero difference, right? Here, there's this big gap between these are the 95% confidence intervals. This big gap shows how statistically significant the effect is. Liberals are talking more than conservatives. Why? Because since 1969, the conservatives have dominated the court. And we call this the losers of history. And essentially, you've got to work harder when you've got to fight, even though it doesn't always succeed. What's interesting is if you look at this in the Australian context, we see the same thing, but even more finely. So here, where we have a majority conservative court, we see the Liberals, the Labor Party, the left party talking more. And then in the other era, when we have the reverse, we have the Labor dominance, we see the Liberals, the Conservatives talking more. Here, what's most interesting in this era, here we see this crossover in the middle of the Chief Justice is to the left, but here the Labor Party actually loses power. And so we can anticipate a move to the right. And what happens? We see this change in who does the speaking more, even midterm. So it's kind of interesting. So we call that the losers of history. And so in terms of answering your first question, I think that's why I think one measure of how liberal the liberal justices are is, well, how much time do they spend arguing at oral argument, really fighting hard? And I think Justice Jackson is fairly left, and so she's fighting hard against the conservatives who are dominating now. And I did, in fact, the second question was about, it was about the language. I think that's a gender thing. We see a lot of women saying, oh, well, I don't know much, but blah, 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 even when they do know a lot. I think that's been studied by linguists. I'm not an expert on that, but I see it all the time. But that's what I think's going on. But I've noticed the same thing. She's very, self-deprecating. What was the term you used?
I said
I
self-deprecating,
guess it's
or like humble, I think.
yeah, like a little bit sort of, and it's, yeah. And I think maybe, you know, I think race comes in there as well. Like a lot of these linguistic patterns are about power. Like, why do women say, may I ask? It's actually, you know, as women achieve higher levels of power, they usually decrease like the amount they're interrupted, for example, because a lot of these patterns are about who has power in society. White men, you know, have traditionally had power. They're used to, you know, talking and being listened to. They're not used to being interrupted. You know, whereas minorities, and also it's a wealth thing as well. Poorer people are interrupted more and interrupt less, etc. And so same with a lot of speech patterns as well. And linguists have studied that in much more detail than me. Yeah, up the back.
Yeah, a quick comment about that, and that is the use of tag questions. Females are far more likely to use tag questions in their general discussion.
What do you mean by a tag question?
You say things like, I think tag questions matter a lot, don't you?
Oh, yeah, yeah, yeah.
Or isn't that right?
Yeah, the English do that as well, interestingly. Don't know why.
But a question that's far afield, but you're the person in the room who would know the most about this. Do you have any view about the kind of education that the various justices have had? In particular, I mean, I've got a theory I'm working with here about their undergraduate educations, because I'm quite struck by, at least as I've understood the reports, a dismissive attitude, a pretty dismissive attitude at times toward social science of just the sort that you do. And it seems as though it's had some crucial impacts, for example, about gerrymandering, that decision. I believe that the famous quote from John Roberts was, "I'm not interested in that sociological gobbledygook." Yeah. Is there, I mean, are they a bunch of history majors who've never studied any social science, and philosophy majors? I mean, I'm a philosopher, so it's not a bit, but is that what's going on? They've got a lot of humanities backgrounds.
I mean,
Done any social science?
I kind of joke sometimes that people go to law school when they're smart, but they can't count. Yeah, there's not a lot of, you know, the high level, not that many people do the sort of work I do in the law because of that general tendency. I don't know about education. I mean, I think most of the people on the Supreme Court have come from, you know, they certainly are Ivy League or equivalent for law schools. I think we're seeing a little bit more diversity recently in terms of undergraduate. But Barrett is the exception, I think, in that she went to law school at Notre Dame. But I don't think it's so much in terms of maybe in terms of lower first degree education, but I think it's more a general tendency in the law to not be that adept at this kind of statistical thinking. But I will also say that they're quite selective, and sometimes they are interested in social science. It depends on the topic. So my colleague Kay Levine is actually just publishing an article on just how selective they are. So trademark, for example, suddenly the justices, you know how to deal with numbers in terms of statistics and surveys on consumer confusion. But in my area, for example, constitutional criminal procedure about, you know, whether a constitutional search has taken place of a criminal defendant. And the question is, does society in general have an expectation of privacy in these circumstances? And the justices just say, let me get out my crystal ball and sense what society thinks yes or no. Like, there's no looking at survey evidence on that. And no recognition that it might vary, for example, with your experiences with the police, for example, maybe, you know, racial minorities might have different expectations to privileged white people, right? And so it's very selective as to when they want to look at statistics and when they don't. So it's partly, I think, a general tendency away from it just because of training. And I think it's incumbent on us as law professors to teach. If not, I don't expect people to come out of law school being able to do this kind of work. That's what you're going to do a PhD for. But you should be able to read it, right? Because you're going to go and cross-examine a witness who's giving expert evidence on, you know, whether this is likely to cause death in a case. Like, you need to be able to talk about statistics. So we need to do a better job of educating. And I think in recent years, there has been a bit of a recognition.
Barring sudden illness, do you see any change in the next few years in the makeup of the court?
I think we must all pray for the health of the justice. You know, I think there's one of my colleagues at Northwestern did a study called Strategic Death. And it's essentially showing just how much more likely you are to die on the court when your political opponents are in power. And so it's not really strategic death, it's lack of strategic retirement, right? And so will we see in, you know, the next 3.5 years, Justice Alito retiring, Justice Thomas? Quite possibly, and then, you know, but I don't think you want that, because then they're just going to be replaced by a much younger version. So
Maybe even worse.
The devil, you know.
Yeah.
The devil, you know.
well, the devil, you know, who's old and got health conditions. So, you know, yeah, I think we'll probably see some strategic retirements. Yeah, and we, you know, and that is a bipartisan affair. Like, you know, it wasn't a coincidence that Justice Breyer retired did. And Justice Ginsburg, like, greatly regret. Justice Ginsburg got a little bit higher on her own product, I think, and couldn't bear letting go of the adoration, and regretted her choice on her deathbed. So, you know, I think a lot of people, you know, do that now. Yeah.
I really appreciate your time.
Oh, yeah.
I'm gonna take advantage of, we are over, you know, it's not unusual,
Yeah.
but I don't want to hold you up.
No, well, thank you so much. This has been such a great interaction.